Hey, Herb, how are you? Good. Can I call you back? I'm on a Zoom meeting. I'll call you back later. I'll call you back this evening. Okay. Okay, good. Thanks. Bye-bye.
Hello, Anthony.
Hey Jeff, how you doing, man?
All right, how are you?
Good, good. How's everything?
Yeah, everything's good. It would be a lot better if you could get out and do some shit, but whatever.
Yeah, sometimes you just gotta, you gotta get out there, I guess, right? Just play it safe. That's
I
all.
have to get out there. That's the biggest complaint I have about all of this. I'm not real happy about staying confined.
No, you and me both. I'm not a big fan of it. Yeah, nice little, virtual background there. And start the recording button here too. Many of you have kind of noticed and saw a lot of our emails. We're doing a lot more of these talks. Generally we're doing anywhere between 1 to 2 of them a month, and we're going to continue to do so. Why? Because 1, it's valuable information. 2, it's a lot easier than, planning a whole, live event where somebody has to drive and, we got to pick out a menu at a hotel or restaurant or whatever the case is. These virtual events are a lot more convenient and obviously they're certainly easier for clients to log on. So appreciate everybody, hopping onto the call today. I think it's going to be a really good session here. We're going to talk in general about estate planning and some of the most important documents that you need to put together. I'm going to pass it off to Lou in a second here because he's going to introduce and talk a little bit more about what we got in store for us. But I just wanted to, obviously say thank you again, and and I hope you enjoy it. If there's any information that you guys would like us to follow up with you on, do not hesitate to ask. We are recording this call, so it will be sent out in a follow-up email. And then, of course, last but not least, we're here to answer any questions. We're here to make sure that all of your questions are answered. So don't be shy. We got a pretty intimate group here. If you need to, take a pause and have us, something reclarified, we're here to do that, and we want to make it as interactive and as beneficial as possible. The only other thing I will say is, the things that we talk about today are not necessarily, may or may not necessarily be specific to your situation. So if there are specific questions that you want to talk about offline, we're happy to do so. So that being said, Lou, take it over, and we'll go from there.
Yeah. So as Anthony said, so we appreciate you guys being on the call with us, and this is kind of our way of giving back to you guys, and just in any way we can. We appreciate the business, and so and that's why we're going to continue doing these things. So just so you guys know, I'm just going to introduce Casey. Casey is a member at Mendelbaum Salzburg. Okay. She specializes in corporate transactions, estate planning. She focuses on business mergers, client acquisitions, commercial transactions, corporate governance, estate planning. I mean, there's a lot of different areas that she focuses in. A couple of the awards that she's gotten in 2019, she was named as in NJ Business Best 50 Women in Business, and she was named by leading women entrepreneurs and business owners as the top 25 leading entrepreneur. And in 2017, she was also named for NJ Business 40 Under 40 for her commitment to growth, professional excellence, and community service. So she definitely knows her stuff. She's an amazing person. And just want to let you know that Casey is not only an attorney, she's also our client. And we're also a client of hers. And, you know, and another thing too, just like, you know, a lot of you guys, over time, we just developed a nice friendship. And, you know, it's just, she's great to work with. That's all I got to say. So Casey, take it from there.
Thanks, Louis. I wish I still qualified for the 40 Under 40 award, but I got in just in the nick of time. Thank you for that. So yeah, like Louis said, I am a client, so I'll be the presenter / the listener today. So I'm just gonna, if it's okay, share my screen. I have a very basic estate planning 101 presentation that I give to our clients and our affiliates and referral sources from time to time. So I thought we would just kind of go through that, but this is a pretty small, intimate group. So I'm happy to be interrupted, ask me questions. Lawyers are expensive. This is free. So take advantage of it. And I'm just going to share my screen. Hopefully I do this correctly. Tell me if you can see it. Can you see it?
We're good.
Yes.
Okay, good. Okay. So when we talk about estate planning, we're usually talking about 3 primary documents. And that doesn't mean that there are only 3 documents that go into estate planning. I think Anthony is going to talk in detail about a lot of different things that are part of the basic estate plan. But when we as lawyers do estate planning documents, we always start with these 3. They are the last will and testament, which is your basic will. This is where you're leaving your assets to one or more family members, charity, whoever. This is the document where you dispose of your assets, where you name your executor. If you have minor children, this is where you name the guardian. If you're going to create certain trusts at the time of your death, this is where you set forth those terms. So the last will and testament is obviously the most talked about document. But anytime we do an estate plan, we always do a power of attorney and a living will. Powers of attorney die with you. So this is the document that allows someone to access your financial accounts or sign documents on your behalf while you're alive. When you die, your power of attorney dies with you. And then the executor who's named in your will takes over those responsibilities. So that's a common misconception about powers of attorney, that they continue after death. That is not true. There are 2 different types of powers of attorney. Durable means it goes into effect the day that you sign it. Springing means that it doesn't go into effect until you're deemed to be incapacitated. So typically when we're doing an estate plan for someone who has a trusted family member, like a spouse or a child or a parent, where they're naming someone who they ultimately are going to trust, we use the durable so that you don't have to worry about being deemed incapacitated in order for your document to go into effect. But we do use springing powers of attorney from time to time. And then the last thing is the living will, which it basically has 2 components. One component is where you're actually giving directives to the person you're appointing and saying, these are my wishes in the event that I cannot make my own decisions. This is what I would like to do. And then the other one is basically a HIPAA waiver, where you're saying, medical professionals, please give my personal information to this person that I've designated so that they can make decisions on my behalf. A living will is not a DNR. A DNR is normally prepared by like a medical facility, like your doctor's office, or if you go into the hospital, you can sign them. Generally speaking, lawyers do not prepare DNRs, although your request to not be given life-sustaining treatment can be set forth in your living will. It is not a DNR. So just wanted to clarify that. Any questions on any of these 3? Okay.
So Casey, actually, I'm gonna have a quick question. So, and again, I on powers of attorney, right? So let's say, obviously powers of attorney, we have the number of accounts that are now controlled through powers of attorneys, right? Maybe clients were deemed as, incapable of handling their own financial affairs. So this is where obviously the most common use of a power of attorney may come into play. I ran into a situation recently where we have a client that obviously now needs the use of a power of attorney, right?
Mhm.
And that power of attorney is his daughter. And because this client was diagnosed with dementia, in the event that this, once that power of attorney is now in force, basically, any instructions from that individual are at this point deemed as null and void. Is that correct?
No, the power of attorney does not take away anybody's rights. The only way to
Okay.
take away someone's rights is actually through a guardianship. So if your concern is that, your loved one has lost capacity and therefore could be taken advantage of, you actually have to do a guardianship, which is a court proceeding that takes away that person's rights. So a power of attorney gives rights to another person. It doesn't take them away from you.
Okay.
It's a great
Just wanted
question.
Thank you.
Yeah. Mhm.
Hey, Casey, I have a quick question for
Oh,
you.
yeah, sure.
If none of those three are in place and somebody gets diagnosed with Alzheimer's or dementia, can they still sign or are they not able to sign?
No, once you lose capacity, you no longer have the right to sign any of these documents.
Okay.
So what happens in that case is if you don't have a will, your assets will pass pursuant to intestacy law, which I'm actually going to talk about in a couple minutes. The power of attorney, you can't sign that. So you'd have to do a guardianship proceeding to actually, someone would have to get appointed. And the guardian would also be the person in control of all your healthcare directives.
And how do you obtain the finances of a person who may become incapacitated due to Alzheimer's?
Like, how do you get access to those things?
Yeah, if they don't have any of that in place, or
Yeah.
once they're diagnosed, that's it, you're out of luck.
Yeah, it's not once you're diagnosed, because even when you have dementia, you have moments of clarity where you actually have capacity. So it's sort of, as the attorney, it's sort of up to us to make that determination when documents are being signed and drafted. I've definitely drafted documents for people who were diagnosed with dementia before, because I met with them and could tell that they were lucid and that they completely understood what was going on and they could answer questions and they knew who everybody in the room was. And then I would have follow-up calls where they didn't have as much capacity. So it's not to say that a diagnosis takes away your rights, but you need to have complete capacity when you're giving the directives for the documents and signing them. So if you've hit that point of no return where you're never going to have the capacity to understand what you're signing, then it's too late. There's nothing you can do. The only thing you can do is go to court and get a guardianship proceeding.
Casey, let me ask you a question with the power of attorney, using the example of somebody that has Alzheimer's or some form of dementia.
Mhm.
And talking about today, 2020, October of 2020, how do you go to court? Courts aren't open.
Oh, courts are open. We are
Yeah?
doing, yes, courts are open. So you don't go in person, it's all virtual, but cases are being heard. There was kind of like a hold that got put on those back in March, April. But yeah, we have many cases being heard in court now.
So in the example that you have to go to court to name myself as a guardian or whoever, how quickly is the process? Time.
So, it depends, which is a typical lawyer answer, right? So there are things that you can do to make it an emergency proceeding and they'll hear it quicker than normal. Generally speaking, you get put on a docket and it takes several months. But if there is a dire need, there are additional filings that you can do with the court to expedite, and it can be done in a matter of days if necessary. The problem with the guardianship proceeding is that the court will actually appoint an attorney to represent the incapacitated person's best interest. And that person has to do an interview and has to give a recommendation to the court on what they think. They're evaluating a few things. They're evaluating the capacity of the person, and then they're also evaluating the guardian. So that process takes a little bit of time. And of course, because of COVID and things like what's going on now, that's delayed. But if it was a situation that was sort of an emergency situation, you can fast track it. This is all handled at the surrogates court, which is the same court that does the like probate proceedings. Okay, so another
Casey,
common,
sorry, one more
Yeah.
question on guardianship.
Mhm.
We have as a son, we have no say in who the guardian is if it comes to that, and then we could petition for guardianship for ourselves, correct?
Yeah, so like if you wanted to become the guardian of like an older parent, is that what you mean? Yeah,
Right,
you would be the one petitioning the court, and the court would decide if you were the right fit to be guardian.
and that could take time, but in the interim, the court appoints a guardian.
Correct.
And what if, it's for my father, I don't know that his wife has his best interest at heart. Can that be a legal battle between us?
Absolutely.
It would be, okay.
Yeah.
If
But it's ultimately not your say. I mean, you basically could say, I want it to be me. She could say, I want it to be me, and the court would decide usually at the recommendation of the court appointed, attorney.
Okay, thank you.
And that's why they do that, because they want to have an independent investigation. So another common misperception when drafting wills is that everything that you own will pass to the person that you name in your will. And that is most definitely not the case. So everything that you own can basically be broken up into two buckets: probate assets and non-probate assets. The probate assets are going to pass pursuant to the terms of your will, but the non-probate assets are going to pass by beneficiary designation. So just to give you some examples of what that looks like, if you own a home with your spouse, generally speaking, that's going to be owned as joint tenants with rights of survivorship, or tenants by the entirety, sometimes it's called. That is a non-probate asset, and it means that at the first spouse's death, that real estate will automatically pass to the surviving spouse. So even if you want to leave your house to your child and you put that in your will, if you own it jointly with your spouse, it will automatically go to your spouse, regardless of what you put in your will. The same stands true for retirement plans like 401ks and IRAs, pay on death accounts, life insurance policies. I can't tell you how many times people come to me and they're like, oh, and I want to leave my life insurance policy to this person, put that in my will. Well, I could waste your time and put it in your will, but it's not going to work, because whoever you name on your beneficiary form is the person that's going to get your life insurance. So it's really, really important. And we always advise our clients when we're doing your will that we talk about what you own and whether or not it's a probate asset or a non-probate asset. And then you need to work with, your advisors or whoever is helping you with these designations to make sure that they're up to date. So, when Lewis is my advisor, and when I meet with him it feels like every minute, but how often do we meet? 3 times a year, something like that. We're
3 times a
constantly,
year, yeah.
we're constantly like rechecking paperwork and saying, okay, do we have the right person designated here? I had another daughter. Do we need to add her to this? Because my will won't actually cover that. So it's a good thing to make sure that you're checking on a regular basis. If you have an ex-spouse, please make sure that you didn't leave that person named on your life insurance policy. That gets very messy. And then anything else that you own is considered a probate asset, and that will pass pursuant to your will. So cash, standard bank accounts, your car, all of your personal property, your jewelry, your furniture, stocks, bonds typically are probate assets, collectible items, things of that nature.
Hey,
So
Casey,
yeah.
real quick, just on the life insurance, can you touch just a little bit on, because we always get this question all the time, usually the spouse is the primary beneficiary, but how about
Sure.
when you have kids underage,
Great question. Okay. So what I like to do, and what I did for myself, because I do have 2 small children, is I basically, in my will, it says that I'm leaving everything to my children in trust, and it gets paid out in 3 specific installments based on them hitting certain ages. And so on my life insurance policy, my primary beneficiary is my husband, and my contingent beneficiary is the trust set forth in my will for the benefit of my children. So that basically makes it so that the life insurance will have to get held by the trustee named in my will so that my kids can't get it outright. Because if you just name your children, it's going to pay out to them when they turn 18. It will go to the guardian until 18 and then pay out. And I don't know about you guys, but I certainly don't want my children getting a hold of millions of dollars at 18. I remember being 18. That would not be good. But that's a great question. Absolutely. Okay. So I kind of alluded to this before about like what happens if you,
speaking.
what happens if you die without a will. So there is, in every single state, there is an intestacy law that says what happens to your assets if you die. And I included this slide here just sort of as an example. This is what the law is in New Jersey, but I don't know where each of you live, but you know, whether it's Connecticut, New York, Massachusetts, they all look almost identical to this. So there's not a lot of difference here. But you can kind of just start with where you're at and kind of work through the chart to figure out exactly where your assets are going to go if you were to die without a will. So, you know, Ivan, if you have, you know, an older parent who is incapacitated, is no longer able to sign a will, doesn't have a will, and you're curious who's going to inherit that money, you can kind of work your way through this chart and it will tell you. And it actually makes a difference whether it's like a first spouse, that you shared children with versus a second marriage situation. All of those factors come into play. So if any of you are in an intestacy situation, feel free to contact me offline and I can help you work through it based on whatever your state of residence is.
Hey, Casey, one
Yeah.
quick item, and going even back one more slide. One of the things that, you know, we've recently started doing, unless the client, you know, is adamant about not doing, is even on, you know, non-qualified assets, which would normally be probate assets. We've been including TOD or POD designations to those accounts, purely for the purposes of, you know, not, you know, for convenience, right? I mean, knowing
Sure.
where those assets are going to go at death, not having any of it tied up through the court or through, you know, having to, through probate, et cetera, et cetera. Is that something that you guys typically recommend or,
you know, you have to evaluate.
Against?
That's a good question. And I think you really have to evaluate that on a case-by-case basis. And, you know, if it's your spouse, it's a trusted individual, someone that you're planning on leaving it to, it's easy. Of course, why not name them? But to Lewis's point, like if you've got small children, you know, or even, you know, not incredibly mature children, maybe they're 20, but not necessarily someone that you want to inherit outright, then it's not a great idea, right? So it kind of depends on the situation. When I'm talking to clients who are more senior and they've got children who are fully grown and grandchildren, and they know that they're going to be leaving assets to, you know, either their spouse or their fully grown children, POD is an easy way to go. I mean, everybody knows that if you get paid on life insurance quicker than everything else. And it's because it's a non-probate asset. So I do agree with that approach. I just think you have to take it on a case-by-case basis, depending on who's being named as the beneficiary. And, you know, this is just a couple of other things that I like to talk to people about when they say, oh, well, if it's just going to go to my spouse anyway, why do I need a will? Well, here are some reasons why you need a will. Getting through the court system, which I'm talking about the surrogates court for probate, when you don't have a will, takes a very long time, longer than if you do have a will. And it also costs a lot more. And that's because you have to have an administrator appointed. So when you name an executor in your will, it's done. That's the person in charge of probating your estate. When you don't name anybody because you don't have a will, you still need someone who's going to probate your estate. And that person's called an administrator. And that person has to get appointed by the court. So there's all this paperwork that has to get filed. You have to justify who you are. You have to give them a whole family tree. You have to notify everybody on the family tree. You have to give them an opportunity to challenge it. It takes forever, which means it costs a lot of money. The other thing is it's the only place where you can actually name a guardian if you have children under the age of 18. executor we talked about, it gives you the ability to leave assets in trust. So, we've talked about this a few times already. If you've got small children, or even if you're just worried about things like second marriage protection or first marriage protection for your children, maybe you trust your children, but you don't necessarily trust their spouse. So you don't want to leave money to them outright, because then it's a marital asset that could be taken advantage of by, your child's spouse. So by leaving it in trust, you can protect it. And so, there's a lot of different ways why people, or a lot of reasons why people use trust, but those can all be created within your will. An inheritance tax liability is an issue that comes up only when you don't have a spouse or children or living parents. So in those cases, if you're leaving assets to somebody other than that, like a friend, a girlfriend, a boyfriend, like a cousin, or nieces and nephews, those types of things, that will all trigger, in New Jersey at least, an inheritance tax. And there are ways to work around that if you use a will. So here are the numbers as they stand today. Give us a couple weeks. I might have a different story for you. But who knows what's going to happen, right? So as we stand today, the federal estate tax is 11.58 million. It's doubled if you're married. We got a 40% estate tax. So if you are under this number, there's no real need to do any tax planning on the estate side. So sometimes we're doing estate planning because we want to worry just about where assets are going and making sure that we have everything going to the right people. Other times we're doing that, plus we're worried about avoiding taxes. So if you have less than this number, you do not need to worry about federal taxes as it stands today. However, the proposal for Biden is about 3.5 million, which is a substantial change, and an increased tax rate of 45%. So we have no idea what's going to happen. There's also a weird situation going on in New Jersey right now where we don't actually have a New Jersey state level estate tax, but we do have an inheritance tax. And everybody thinks the state level estate tax is going to come back, but we don't know the amount. If any of you are New York residents, it's about $5 million exemption in New York. So suffice it to say that you have to kind of take it on a case by case basis when you're looking at different clients and how much money they have, whether or not you have to do specific tax planning, but it doesn't change the need for the 3 basic documents. The only thing that really changes is whether or not you're going to do any gifting to reduce your overall estate so as to avoid paying taxes at death. So easy ways to reduce your estate tax. If you're married, you use trusts set up in your will, and that will completely avoid any taxes on the first spouse's death. If you're not married, you have to worry about things like gifting to children or other loved ones. So currently, and again, this is all subject to change, the gift tax exemption and the tax rate are all the same as the estate tax. You're also allowed to give any one of your family members $15,000 per year, or something valued at $15,000 a year, $30,000 if you're married. And we do gifting, like I said, in order to reduce someone's gross estate so that they don't have to pay, or their loved ones don't have to pay, an estate tax at death. And there's just this is kind of a simple chart that explains the different ways to do that. So you can do an outright gift. I, Jeff, am leaving you, my daughter, this sum of money. That's simple. It's outright. But there's pros and cons to that, right? You aren't protecting from creditor claims. It's subject to marital estate. So if there's a spouse out there that you don't like, a son-in-law that you don't like, he's going to have access to it. The great thing about gifting with trust too is that you can name who gets the money if there's anything left when the person you've left it to dies. So you can name the next person in line. So this is, I don't need to go into too much detail. I know Anthony has some things to talk about, but I just wanted to give you sort of a general overview of why we do certain gifts versus others. For those of you who are charitably inclined, I don't know about you, but the only deduction I get now is my charitable gifts. So I'm a big fan of those, but it has a nice income tax deduction in the current year that you make it. But of course, that's reducing your estate and what you're left with to give to your family members. So pros and cons of everything. Does anybody have any questions about estate planning, gifting, taxes, Anything that's on your mind? I can't tell you what the rate's going to be next year. I have no idea.
I have a quick question. I have actually two questions. One, just typically just on, like Anthony said, with the transfer on debts or any retirement plans, or even life insurance, a lot of the times too, for the children, when they're the contingent, let's say they are older at this point, we're always adding in the persterps on there too. So in the event that, God forbid, something happens to one child and they have grandkids, that lineage gets
Yeah.
that percentage of the
Yep.
money. Good, right?
Yeah, it's great to add in the persterpes language. We put it in all of our wills and all of our trusts, if that's the intent.
Right.
But again, if you put it just as a beneficiary designation, you're not using a trust. So it's just going to automatically go to that person. And if the grandchildren in line due to that persterpes language are small children, it's going to go to their guardian.
Okay. And
Now, see, go ahead.
no,
Go
go ahead,
ahead.
Jeff.
Oh, well, I know what I did with my father who had dementia. My mom died, 10 years earlier. And once I could see my mom wasn't alive, she handled a lot of the financials, paying the bills and everything.
Mhm.
I opened up a joint account with my dad, naming me. I didn't have the checks. He had the checks, but I opened it up with the ability to pay bills. And it ultimately came in handy because he neglected to pay his auto insurance for about 6 months, unbeknownst to me.
Yep. Absolutely. That's a great thing to do. And that's, it's a great reason why people should set up powers of attorney, because you never know what's going to happen. And that power of attorney would allow you to access those accounts, put yourself on the accounts, and do whatever you needed to do. So great point. Any other questions?
So I don't really have a question, but kind of more or less like, a comment. We briefly talked about trust, right? In a general nature, and there's a lot of different uses and reasons why one would use them. Oftentimes there's, I guess, a misconception that trusts are only for the uber wealthy. You don't need them unless you need to, shelter, the 24, $23 million exemption, et cetera, et cetera. And the reality of it is, I was with a client last night and they asked me about trust and what are they and what are they for? And my simple answer was control. I mean, it's essentially, conceptually, you can look at a trust as a means to provide rules and regulations on your money, even when you're no longer here, basically.
Absolutely.
I mean,
And it really doesn't have anything to do with having a lot of money. I mean,
it could be anything. Yeah.
there's so many reasons to do trusts. I mean, in New Jersey, up until very recently, we only had an exemption amount of 675,000, which means almost every single person in New Jersey who owns a home is going to be subject to the New Jersey estate tax. I don't think it's going to come back at that level. I think it's probably going to be at least 2 million, but even still, because of that, we were putting everybody's life insurance into a trust because then it's not taxed. It doesn't mean you're rich. It doesn't mean you have even access to the death benefit of that money. But what it means is that your estate is going to get 100% of that cash and not have to pay tax on it. So there's a great benefit for using a trust for that purpose. Like I said, I have trust for my daughters, not because I have so much money, but because I don't want them to inherit any money when they're only 18. So there's all sorts of different reasons, but you nailed it when you said it's control. It gives you the ability to dictate who gets the money, when they get the money, how the money is spent, and then if there's any money left, who it goes to next.
Casey, can I ask a question about the power of attorney?
Sure.
If I was to do a power of attorney, say today, then I would be doing a springing. Is that what I would call it?
So it depends on who you wanted to name as your power of attorney holder. So if you were going to name your spouse or your one of your children or somebody that you trust to have access to your financial stuff now, we would do it as a durable just because it's a lot easier to implement. But it means that it goes into effect today. So you have to basically trust that that person's not going to use it today.
Right.
If you were naming someone that you don't necessarily trust at that level not to use it immediately, then we would do a springing.
Okay.
The problem with the springing is that in order for it to be put into effect, you actually have to go to a doctor and get like written confirmation that you, Linda, are no longer capacitated, and therefore I, Casey, the power of attorney holder, have the right to use this. So it's not like I can just run to the bank and use it or just sign my name to something. Like I have to go to a doctor, and it just takes a while. So whenever we have someone where there's a trusted relationship, now we go with durable. And then if not, we use springing.
Okay, thank you.
Mhm. Any other questions?
I was just gonna say maybe just touch base on or touch on because you know I've been recommending with clients, especially when they have like 18-year-olds going to college, you know, the importance of getting a health proxy and things like
Oh,
that.
right. Yeah, that's a
Right.
really good point. Really, really good point. And people lose sight of the fact that your kids are your kids, except when they turn 18, they're actually not considered children anymore under the law. And so because things have gotten so crazy with HIPAA regulations, that's the biggest one, HIPAA regulations, banking regulations, lending institutions and hospitals, medical providers of all kinds are very reluctant to give any kind of information to parents once the children turn 18. So if you have kids in college or grandkids in college that are 18 or older, they should have a power of attorney and a healthcare proxy, naming their parent as their person. Because could you even imagine a situation where you have a child who's in a different state in college and gets into a car accident, and you call the hospital because you can't get there for a few hours because you're waiting for your plane or whatever, and they won't give you any information because your kid is over 18 and they don't have a healthcare proxy? I mean, that's just awful. So when the way that we do estate planning, typically, not always, but typically, is we typically do it on a fixed fee basis. And so if we're doing estate planning for the parents of adult children, we will kind of toss in the power of attorney and healthcare proxy at no charge just to make sure that they're covered.
But Casey, let me ask you a question in that case where you have a child that's at a college 2 states away or whatever the case might be.
Mhm.
In order for that hospital to disclose any information, you have to either fax it, scan it, or whatever to get it in the hands of that hospital.
Correct. Correct.
I just have one other quick question. It's not necessarily specifically about some of the things that you went over. I know we have a couple business owners on the line, and you know, some clients that own quite a bit of real estate. Using trust for the purposes of owning a business or real estate, is that common practice? Is that typically?
Not really. We do it sometimes, but I prefer to use LLCs. They're so much easier to deal with. They give you almost all the same protections and control. They're way easier. And so, I mean, as Lewis mentioned in the beginning, I represent a lot of business owners. I do a lot of corporate transaction work, and I do estate planning for most of them. And so what we do is, you know, we put real estate in LLCs, we put businesses in LLCs. Sometimes we layer them with parent companies over, you know, if we need increased liability protection for any reason. I'm sorry if you hear my daughter's crying in the background. And then what we do a lot of times is if we're going to do gifting, we'll actually gift interests in the LLCs to the trust. So we're not actually putting the real estate into the trust. We're putting the LLC interest into the trust, and the LLC owns the real estate. But it's super hard to deal with real estate that's owned by trust, just from like, you know, when you're going out and getting mortgages and doing refinancing, same with businesses. So it's a lot easier to use like corporate entities like an LLC and then gift those into the trust if we need to.
And the gifting, the interest would be a mechanism to reduce the estate.
Correct. Yep. Mm-hmm.
Good.
Yeah. Yep. Absolutely.
A quick question, Casey. With the election coming up, what's happened to your business? I mean, that had to have had an impact on you. How are people behaving?
So that's an interesting thing. We've seen so many things happening since COVID, and now with the election coming on. I've never been busier in my career. And even in 2012, when the law was changing and we were just cranking out wills like we were McDonald's, it was like, I thought that was bad. This is worse. So everybody wants to take advantage of these really high gift exemptions because they're not sure if they're going to go away and if it's going to be retroactive and we're going to lose the opportunity next year. So from on a corporate side, so many people are buying businesses because there's just tons of inventory out there. So we're doing tons of corporate transactions. And then on the estate planning side, we're doing lots of gifting, like giving everything to your family members, putting things in LLCs, putting things in trust, moving things around, reducing your estate, because the idea is that if you actually have, you know, a pretty large estate and you gift it now, they're not going to pull it back into your estate later. They're going to honor the fact that this was the law now. And so even if they reduce it down to 3.5, you will have gotten, you know,
You've been
potentially
grandfathered.
12.
Yeah.
Right. They're not right. They're going to grandfather it. So the 22 million people are taking advantage of the ability to gift that away now.
It makes sense.
Lots and lots of estate planning, lots and lots of corporate transactions. When our office closed briefly for COVID, we really thought this was going to be like this recession, and we all like took no salaries and, you know, pay cuts and all this stuff. And like we've already passed our like goal for the year in like August. I mean, it's insane between the political climate and the COVID pandemic. I mean, law firms are just drowning in work. It's fun, but it's hard, and I don't sleep very much.
You got young kids.
Well, that's true. Yeah.
I think earlier in the year, you might have, you were writing a book. Read that correctly? Were you writing a book?
I wrote a book last year.
Oh, that was last year. Okay.
Yeah. So I published a book last year called Buy, Sell, Merge. It was released on October 1st of last year. And then I started another book, which I had a baby in COVID instead of finishing. But the second book is more about like how to be a working mom, how to have a career and be a parent at the same time. So it's a time management book.
Beautiful. Nice.
Yeah.
Any other questions for Casey? I don't want to, if she's got a crying child, I don't want to keep her too much.
It's okay. She stopped. We're all good.
Well, look, I would suspect, I'm assuming that you're still open to new clients, correct?
Always. Yeah, of course. I mean, there's always capacity for more, right? We just want to make sure that everybody's taken care of and everybody's taking advantage of the laws as they are today. I think what's going to happen is this craziness is going to take a slight break in January, and then everybody's going to realize that, you know, the sky didn't fall and February is going to get busy again. So I'm looking forward to taking a little break in January. But other than that, you know, anybody who needs help with whether it's on the estate planning side, on the corporate side, you know, my door is always open. Feel free to call me, email me. I'm happy to help in any way that I can.
Great. Well, look, I know that we have, I want to touch on one other item here. If Casey, by all means, we sincerely appreciate your time. If you need to hop off.
I'm fine. No, I'm interested to hear what you say.
Okay. All right. So what I want to talk a little bit about is, a piece that we put together several years ago that we call the 25 documents that you need before you die. So everyone should be able to see my screen at this point. And we're happy to send this out to you, but in addition to the items that Casey just spoke about, there are a number of other things that one needs to consider, right? And then there's a number of other ways or things that you need to be aware of, right? And the big conception or the big mantra is, do you know where everything is, what is entailed, and how to get to it, right? And that's ultimately what this document is for. And, you know, every so often with our clients, we go over these items to make sure that they're in place. And if they're not, we assist in making sure that they get them in place, right? So, you know, talk about number one, right? Your emergency contacts. Do you have a list of emergency contacts? For married individuals, maybe it's just your spouse, right? But is it written down somewhere, and can, you know, can an emergency professional access it should you be incapacitated for whatever reason? You know, oftentimes it's as simple as putting in your spouse as your ICE contact in your phone, right? Law enforcement professionals are trained to look at somebody's phone and target, you know, contacts named ICE in case of an emergency, right? Or, you know, including emergency contacts somewhere within your car. Medication and supplements, right? Do you have a list of medications and supplements that you're taking? I know we have one medical professional in the room, but I'm sure everyone kind of can attest to the fact that if you've ever gone to the hospital, one of the first questions that they ask you is, what type of medications are you taking? And they don't, you know, they don't ask that because they want to know. They ask that because they need to make sure that anything they give you doesn't interact with anything that you're taking in a negative manner. And if they don't know what you're on, they're limited to what they can give you as far as the treatment is concerned. Okay. The same goes with your medical history. These items can be or should be written down and or stored somewhere that you have access to. Okay. We talked obviously, you know, about the medical power of attorney, the durable power of attorney, living wills, so on and so forth. This is obviously where Casey and her firm come in. Okay. Your health insurance information. Do you carry your card or do you leave your card at home? I mean, I know obviously, you know, men have thick wallets. They put just about everything because in general, men are hoarders. But are you making sure that your health insurance card information is in there and you have access to it? And whether or not you want to donate, you know, you're an organ donor. Obviously, I know this is now something that's on your, you know, on your license. But that is something that you want medical professionals to have access to, you know, in the event that something were to happen rapidly and quickly. Okay. Banking and investments. So this is big, right? Do you have some sort of program or system that lists all of your banking, investment, annuity, or retirement accounts all in one place? And does your emergency contact know how to access it? This is a big question, you know, because many people do not. And many people find out the hard way. Well, mom and dad have accounts here. They have accounts there. They have accounts everywhere. I don't know who to call. I can't access them. They're all over the place. And it takes months. And I'm sure Casey deals with this all the time with, you know, with trying to probate a will and locate all the assets and divvy them up and so on and so forth. It becomes a mess. And you hear horror stories about estates that take years to unwind because nothing is, you know, nothing, there's no organization. So you know, listen, we understand that many clients and many individuals are going to have multiple advisors. While we would love for all of our clients, for us to, you know, be in charge of all of our clients' assets, we're realistic and we understand that that's just not necessarily the case. But are you using some sort of system and program to list and show where everything is, how to access it, and who to contact for the purposes of accessing those accounts and those vehicles? This is huge. We do have, you know, and I'm just going to mute Joe real quick. We do have a program that has the ability to do this for you, and we enroll our clients in this program, or I should say, we enroll our financial planning clients in this program. It's a lifesaver. It'll put whether the money is with our firm, whether it's with Fidelity, whether it's with Vanguard, whatever the case is, it's all in one place, and your emergency contacts will know how to access it, who to contact, and what to do. Okay. The same goes for your insurance policies. Most people have more than one life insurance policy, disability, et cetera, long-term care, et cetera, et cetera. I know I myself have 3 life insurance policies, alone, right? I have just 2 disability policies as well. If something were to happen to me and I didn't utilize this program that puts everything all in one place, because of the nature of the business that I'm in, my wife wants absolutely nothing to do with the finances, but she needs to know how, and should something happen to me, how to access and what to do in the event of an emergency. The estate planning aspects we talked about. Again, the powers of attorney, the wills, the estate plans, the copies of those estate plans. But where are they stored? Do you have access to them, right? Are they in a PDF copy or are they in a hard copy? We already know that you need to keep one sealed hard copy of your will, right? But do you have access to it should you ever need to reference it? And then
Can I
last but not
interject real quick there? This is a really great point. Because the only way to probate a will is to have the actual original, people think that they should put it someplace safe, like a safety deposit box. Please don't do that. The only person who can access your safety deposit box would be your executor who's named in your will. And so if the document is inside the safety deposit box, we can't figure out who that person is. So unless you've made your executor have access to your safety deposit box and they already are like named on that account and have a key, that is a bad place to keep it. When we do documents, we keep them in our fireproof vault in our firm, and then just send our clients certified copies that are stamped at the top that say the original is being held at Mandelbaum Salzburg, so that anybody who finds it will know to call us. But you can put it in a fireproof file cabinet in your house. That's a better choice than the safety deposit box. So just figured I'd throw that out there.
Absolutely. No, it's a great point. It's a great point for sure. And then last but not least, right? Your websites and your passwords, credit cards, mortgages, other important documents that you may have that are specific and particular to you. Does your significant other or whomever will be handling your estate know how to access these areas, right? The websites that they may need to access? Are they named as someone with special authorization, so on and so forth. So, look, we run through this information with our clients to make sure that, when, for lack of a better word, when the shit hits the fan, right? And you think, and you're in a panic, in and of itself, the reality of it is having this type of organization will be able to provide a level of calmness and a level of, and a solution to your panic. So, I mean, again, I'm happy to send this document out. It is crucial. It's important. These are what we feel are the 25 most important items that you should check off your list. Now, you may not need all of them, right? You may not have all of them, but you can check, and if that's the case, you cross it out. But at least you use it as a checklist and a guide to be prepared in the event of an emergency.
Yeah, and yeah, I'm just gonna add to this too, guys. Usually what I'll do is I put it on my calendar once a quarter, where I'll actually, my personal one, I will update it, especially these days, because constantly you have to update passwords all the time. And so, if you just do it once a year, you may have changed the password 3 times throughout that year. So I think that's truly important. And especially now with email, I think it's highly important because we're moving to a paperless society. Where a lot of people are getting all their statements by email. Nobody's getting really a lot of mail anymore. And so you may miss a payment for a parent or something like that you're not aware of, because you're not just going to their mailbox anymore. And just like regular statements. So, you may not be aware that your parents have, certain accounts, certain places. And if it's not coming in the mail, you're really not knowing where it is, that it even exists.
a great point. It's a great point, Lou. We have any questions? Everybody's too tired.
No, this is very interesting.
That's a good list. Thanks for sharing it.
Good, good. Well, look, I mean, you know, that was the bulk of what we wanted to talk about here tonight. You know, if there's, you know, again, our door is always open. If there's any further questions, you can certainly feel free to reach out to either myself, Lou. We are also going to be sending out a follow-up email with a recording of this conversation. We'll include Casey's contact information in that, you know, in that email. Should you, you know, need to contact her and utilize her firm also. Before I end, I just want to ask one more time if we have any additional questions or if there's anything else that anyone would like to say before I end it. No. Okay. I
Good
got
job.
one question. Oh, sorry. Go ahead. Did I hear something? No. Okay. I do have one question. So we prepare, you know, obviously, as I said, 1 to 2 of these videos a month. Now we schedule them out typically a good, you know, 3 to 6 months in advance, but we always want to take into account what our clients want to hear about, want to learn about, and want to know. Some of the events that we're going to do are purely just going to be entertainment and enjoyable because we need that. It doesn't always have to be just about education, but education and knowledge is crucial and it's important. We would appreciate feedback and suggestions, and it doesn't have to be right now. I'm not going to put anybody on the spot, but if you could follow up with us either via email, text message, whatever the case is, with any thoughts, any ideas, any suggestions on topics that you may want to hear about, we will absolutely take that into consideration. The next event that we have coming up is going to be about tax harvesting and things that you need to prepare for in order to reduce the tax the tax bite come April, but that you need to do before December 31st. So that'll be the next event that we have coming up for anyone that's interested. But we do want to hear feedback. We do want to hear suggestions. So please, you know, follow up with us, like I said, either via email or text message, or even just with a phone call, and let us know any ideas on topics that you want to hear. Lou, is there anything else that you want to say?
No, I love that. I mean, I 100% agree, and it doesn't have to be anything financial at all, you know. But we have a couple different ideas that we're working on too, that we think will be great. But if you guys know even of a speaker, somebody that you've listened to in the past that you thought would add value to us and our clients, I mean, we'd love to get that person's information as well, and maybe put them on the list as our guest.
Great.
Okay.
All right, listen, we can't thank Casey enough for her time. We really appreciate it. You know, and
Thanks for having me.
Yeah,
It's nice to
absolutely.
meet you all.
We hope that you guys got value out of what she was talking about. I certainly have. I learn a little bit every time I hear it. You know, I hear her speak. So we appreciate it. And listen, I thank you guys all for joining us. Thank you for the continued support. And you know, we look forward to seeing what happens on the election next week.
Good job, Anthony and Lou and Casey. Good job.
Thank you, guys.
Thank you.
Thanks, Casey.
Appreciate all the help and input.
Absolutely.
Thanks,
Take care,
guys.
everybody.
Take care,
Have a good
everybody.
night.
Good
Have a
night.
good night.
Good night.
Bye.
For a walk.